Ms. Montori, you may proceed.
May it please the Court, I'm Jane Montori, arguing on behalf of the Commonwealth, representing the District Attorney for Hampden County. This case is before the Court on a reservation and report of the single justice and addresses a continuance of a dangerousness hearing under Section 58A. And the narrow issue really is the manner in which the Commonwealth is allowed to demonstrate probable cause.
Was there a probable cause finding in this case?
Not specifically on the record, Your Honor.
Right. Well, I wonder why your brief doesn't seem to address the juvenile's argument that in this case there was no probable cause finding.
Well, there wasn't any. I mean, she didn't find probable cause. She didn't find no probable cause. And I think that's what we're left with in this record. So that in this case there was no probable cause finding? There was no finding whatsoever.
Okay. And what is your argument if there's been no probable cause finding?
Well, I would ask this Court to give direction to the lower courts to make a probable cause finding on the record. I think in cases where the person is detained for the 3-day continuance period, we can presume that there was a probable cause finding.
Well, I'm confused. There was a complaint issued here, yes?
There was a complaint issued.
All right.
And it's the Commonwealth's position that under the new Rule 3G, that now the standard for issuance of complaints in all criminal cases is the same as that for the issuance of an indictment. And there should be some sort of record in the file of the basis for the issuance of that complaint. Now, there was no record in this case. I inquired of the clerk as to why there was no record. They indicated that, well, the rule was new, and also in this case there were a good number of co-defendants, so perhaps the basis for the issuance of the complaint just never made it into this particular file. Now, again, we would ask the Court to give direction to the lower courts that under the new rule that there be some sort of recording in each file for the basis for the issuance of the complaint.
Well, if we adopt your position that the issuance of the complaint or the indictment is a sufficient finding of probable cause, then how does the statute make sense? It would have the defense attorney be there, I think, as the defense counsel pointed out, just to be a babysitter, because there's a provision in the defendant has the right to be represented by counsel at the hearing and has the right to cross-examine. If there's no hearing, how does all that happen?
Well, there would be a hearing, Your Honor, and presumably the defense attorney would have copies of...
Wait, I thought you said no hearing because the probable cause finding was of complaint or indictment was sufficient.
No, I'm sorry, I didn't make it clear. No evidentiary or adversary hearing. No evidentiary hearing.
So, okay, so right. So then what would the defense counsel be doing?
What would the judge be doing?
They would be arguing that there was not a sufficient showing of probable cause.
So it would be like a motion to dismiss, in other words.
A motion to dismiss without the evidence.
You mean like reading the police reports?
Correct. Or the judge would have discretion, as they do under Section 58, to accept the police report or to accept the prosecutor's recitation of the facts from the police reports, witness statements, etc. It's the Commonwealth's position that there should, at this stage, in order to hold the defendant during the 3-day continuance, there should not be an evidentiary hearing.
Well,
on what?
That on probable cause.
On probable cause.
There surely should be. I mean, I was sort of surprised here. It seems to me that in connection with getting a continuance to have the hearing, which is what we're talking about, to get a continuance to have the detention hearing, Commonwealth needs to show two things under the statute. One, that there's good cause for continuance based on our prior case law. Even though it's only a maximum of 3 days, still has to show good cause.
Certainly.
And I was a little surprised that this was accepted as good cause. It's late in the day, is not really, doesn't seem to me to be necessarily
Surely that
good
cannot
cause.
be good cause. For the judge to say it's 4:30,
I'm going home?
I'm going home, that's good cause?
Well, she accepted that as good cause.
Who
or
accepted that?
Or the judge actually was the one who
Right.
proposed that as being good cause.
All right, well, I found that a little surprising. So what we're talking about here is a very you've made your motion for detention, right? It's a proper crime that would require it under the statute. If you've shown good cause, I take it your argument is, in order for you to also, only other showing you have to make is there's probable cause that the arrest,
Probable cause
to arrest the person,
Right.
which is exactly the same standard that the magistrate would have used in
Issue the
issuing the
complaint.
complaint.
Correct.
And that, prior to our change in the rule, that wouldn't have been the case necessarily.
That's right. If there was an arrest without a warrant,
Right.
that would not have been the case. In that case, it would have been just a magisterial issuance of the complaint to set the criminal process in motion.
So whatever the statute may have tried to ensure at that point in time, it isn't really necessary to have a separate showing other than the issuance of the complaint or the indictment at this point.
Well, that would be one way. Now, of course, it would be in the judge's discretion if there was a thin showing.
Or tell me more about this. I want to know more about
Right.
this.
But then what do you do
Isn't that
with the...
conceptually linked to the detention? In other words, the judge isn't going to dismiss the complaint, correct? But if it's a thin showing, if the police officer
No,
report, right, you're now moving for detention, correct? That's what the Commonwealth...
And this is only just about the continuance, getting a continuance, as opposed to an immediate hearing, getting a 3-day continuance.
Correct.
But
You
then
have
what
to
do
show probable cause.
What do you do about the sentence right after that, which obviously refers to that hearing, which says, "The person shall be afforded an opportunity to testify."
But that's
To
at the
present
hearing.
witnesses, I don't think so, to
That's at the
cross-examine
detention
witnesses.
hearing. This is not a detention
Well,
hearing.
I believe
This is
that-
a continuance.
Well, it
Mendoza...
depends how you read that sentence.
Mendoza indicates that refers to the actual detention or
hearing.
dangerousness hearing under that subsection of the statute.
Ms. Montoya, forgive me. My understanding was that the Commonwealth moved for detention, correct?
Correct.
And then the question arose as to when the required hearing would take place, correct?
Yes.
So let me just deal with the first part. If it is now the case that, from your point of view, the magistrate issuing the complaint makes a determination that there is probable cause, footnote, there should be some notation to that. The judge is not reviewing that as the judge would if there was a motion to dismiss the complaint, for example, but the judge might be reviewing it in connection with whether or not to detain this defendant, correct? In other words, if it looked as if this was a very thin case, the judge might not be inclined to issue an order of detention. It's in that sense that the judge might be reviewing the probable cause to issue the complaint. Am I understanding you correctly?
To the ultimate issue of detention, I'm not clear
Well, I'm trying to
on-
separate them, because that's what I said. You filed a motion. Then the issue arose as to whether or not the hearing should proceed immediately or be continued. It seemed to me that that's an entirely separate thing, and that only goes to whether there's good cause for a continuance.
And there has to be, in order to detain the defendant during that continuance period, which, if the Commonwealth requests the continuance, it's 3 business days. In order to detain the defendant during that brief time, the Commonwealth has to demonstrate probable
Of
cause
course.
to arrest.
Of course, because otherwise, that
It would be a violation of due process. But in all cases that I could find where there's a necessary showing of probable cause to arrest, there is not a necessity for an evidentiary hearing, and that's what was requested in this case.
But does the judge have discretion? The judge looks at it, and, the judge could, if the judge wanted to, correct?
Correct. certainly the judge could, just as the court said in Paquette, that the judge in some circumstances has discretion.
May want to.
May want to.
Yes.
Well, the defendant here, well, a defendant, not the defendant here, a defendant could, I suppose, conceivably say, I was in a jail at the time this crime took place, and here's the certificate from, or the affidavit or something from my jailer showing that I was in jail. Or he could say, I am not the John Jones that is described in the complaint. I mean, I suppose theoretically you could at least give the defendant the opportunity to
certainly.
come forth with that kind of information.
Certainly, because the defendant clearly has a right to be present. That's stated in the statute, that it has to be at his first appearance before the court. And LaValle said he has a right to be represented by counsel, and that would be counsel's function to challenge that the Commonwealth has not shown that a crime had been committed or that this defendant committed the crime, which is, of course, the necessary showing for probable cause.
But we never really got to that here because the judge, as far as I can determine, essentially said it's 4:30. I'm not going to go forward.
Well, she did then ask the prosecutor for a recitation of the facts, but she referred to good cause. She didn't refer to probable cause. So again, there's a lack of a record here. And the prosecutor did set out the facts of the crime and the facts of this defendant's statement, which linked him to the burning of the building, the breaking and entering, and the larceny over $250.
But did he? Is it true that he never did confess?
Not to my knowledge, Your Honor.
No, it appears that the admission really relates not to the burning of the building, but rather to having participated in stealing stuff from it or something. Now, I don't know why the case was ultimately dismissed, but if you look at the admission carefully, there's no admission really that he participated in burning the building.
Based on that record, yes.
Right. But this case was dismissed.
Right.
Right. Okay.
The arson was null prost.
All right.
He was given a disposition under 276-87 on the other two charges.
Okay. So the underlying I see. Just the arson was null prost, but
Yes.
the underlying charges were actually there was a
Because
disposition.
after investigation, it was found, according to the null prost that was filed, and it's in my sister's brief at 11.
Stated differently, what I'm trying to get at is there's a request for a continuation and that the juvenile be detained during that period of time. It's a twofold inquiry that the court makes, correct? One,
Yes.
was there probable cause? And two, what's the good cause for the continuance? And it seems to me that it's unclear what the probable cause was here, although there was this recitation. But what's the good cause here?
The good cause wasn't an issue before the single justice. The good cause was the lateness of the hour. It was apparently 4:20.
And what difference does that make?
Well, I don't know.
I mean, that
frankly.
surely can't constitute good cause, correct? I mean, you can perhaps put it over till the following morning, or you...
Well, it would constitute good cause if the judge wanted to hear from the police officer or something. And
Who were not
But
available.
but
I mean, that's a slightly
Right.
different.
But there's no indication on this record that that was the case.
No,
Correct?
the
And
judge-
the judge could equally have said, Commonwealth, you know what the requirements are. If you want to detain, even overnight, come in with, whoever you have.
Well, but it is good cause if the witnesses are not there, and often that's what
Doesn't that
happens.
imply that you have to have an evidentiary hearing?
On the dangerousness portion of in order to detain the defendant, you do have to oftentimes have an evidentiary hearing, or you can use reliable hearsay, but that's at the judge's discretion.
I understand, but here you can have a perfectly good hearing. There's no indication, as I understand it here, that the Commonwealth said, I need the live testimony.
I think the Commonwealth was about to say that, and the judge preempted it by saying, we can't have a dangerousness hearing at this hour because it's going to take longer than however time the court had left.
So you're saying the Commonwealth was prepared to go forward?
It's not clear on the record. I believe she would have
And they may not have been
asked for a
prepared to go forward.
continuance. They're usually not, quite frankly, just because getting police officers in, if that's to have them ready if necessary. In this case, there were arson specialists involved. And the other question is, if probable cause to arrest and good cause are found, is the court required to detain the defendant during the continuance period? And it's our position that yes, that the word shall in the statute clearly indicates that they are required to be detained, as well as the purpose of the statute, which is to prevent crimes being committed by people who are being held for trial.
But the flip side of that is if there's no finding of probable cause and there's no finding of good cause, then the defendant shall not be detained.
If there's no finding of good cause for the continuance, then presumably the hearing would have to be held forthwith.
And the issue of probable cause in that sense then becomes moot.
Right.
I mean, presumably that could be an issue at the substantive hearing where the defendant makes a very persuasive showing that he wasn't there. He couldn't have done this. But that would be, in essence, part and parcel of the detention hearing.
Right,
Or
and
could
that's
be.
one of the factors that is listed in the statute, the nature and circumstances of the crime that the court is required to consider.
So, Montoya, let me just ask you this. Let's assume that the judge determines that there is probable cause for the complaint to issue but not to detain. You're saying that the judge has no discretion?
Well, it's
Under
probable
the
cause to
statute.
arrest. Isn't it probable cause to arrest?
Probable cause to arrest. If the judge finds that there's probable cause to arrest, if a continuance is requested and the Commonwealth or defendant shows good cause for that continuance, and if the Commonwealth demonstrates probable cause to arrest, it's our position that during that continuance period, the judge must detain the defendant, that the judge does not have discretion. And that's clear from the language of the statute. And even going beyond the language, the court, the legislature knows how to use discretionary language, knows how to say may, and also looking at the purpose of the statute, which is to protect the public from individuals who are likely to reoffend while awaiting trial.
But isn't that the difficulty that I'm having, apart from statutory language, is that typically when you're having a detention rather than, release before somebody is proved to have committed something, it's because they're likely to, we had the 58 A's or whatever it is, they're going to commit another crime, or they're going to, you may have a very strong case for a first-time offense.
But this is a 58A.
Right.
This is a 58A hearing we're talking about.
Yes.
Yes, but you're saying that if there's a continuance sought, in fact, the determination has been made before you had the hearing.
No, the determination of dangerousness?
No.
Well, in
No, but
essence, you're
the
saying
statute provides in certain offenses, for certain kinds of offenses, limited offenses, the Commonwealth has the right to move for a detention.
Right.
Yes.
All right? Once they've moved, establishes, they have a right to a hearing. If they can't go forward immediately and they can establish good cause and assure the court there's probable cause for the arrest, which is fairly easy to do, in my view, under these circumstances, then they have a right to get a continuance, a very short continuance.
Very short.
To put on the case for detention.
Yes.
But as I understand it, what you're saying is during that period of time, and if the normal explanation is I don't have time to get my police officers, the judge has no discretion to release the person for a very short period of time.
If she finds or he finds that the Commonwealth's reason for the continuance
Well, put it this way. The
good.
reason for a continuance is usually lower than the reason to detain somebody. And so I would be a little concerned if we were saying to judges, be very careful if you grant the Commonwealth a continuance, because you're going to have to detain this juvenile for up to 3 days, provided that...
But the standard of probable cause to arrest has been met.
Yes, but you don't automatically get a detention in the event that everybody charged with this particular series of crimes doesn't automatically get detention. The Commonwealth has another further showing to make, correct?
Correct. Correct. It may be that
So
after
the question is, where does the burden fall within that period of time? If the Commonwealth knows that, quite reasonably, it says, I can't get the police officers here, the person is going to be detained in any event for 3 days, as opposed to, if I can't get the police officers here, I may be able to have the hearing in 3 days' time. I don't have to have it now, but I'm not going to be able to detain the person during those 3 days period of time. It may make a distinction as to whether the police officers are brought or not brought, correct?
I think Mendoza actually addresses that it's very difficult for the Commonwealth in a brief period of time to meet the standard of dangerousness in order to detain the person pre-trial for 90 days. And that's why continuances are often sought, but a good cause has to be shown.
I take it the federal statute is modeled after this, but even provides for longer periods of continuance, or am I wrong about that?
I think the difference is in the federal, and I could very well be wrong.
I'll withdraw the question. You don't have to get
One
into
is
that.
3 days, one is 3 business days.
Okay.
And if there are no other questions, I would rest on my brief. Thank you.
Thank you, Ms. Montori. Ms. Kushner?
May it please the Court, my name is Erica Kushner, and I represent the juvenile in this case. With regard to the probable cause determination, I would state to this Court that the arson complaint that was the requisite predicate offense was invalid because it was issued without probable cause. And therefore, I would raise to this Court the jurisdictional question that the complaint for arson, which
How can we make that determination, by the way?
you can make that determination because it wasn't provided as provided in the rules. Mass Rule Criminal 3G2 states there has to be a probable cause determination. The Rule 11 of the Uniform Trial Court rules further states that that has to be in writing. And I similarly went to investigate this at the juvenile clerk's office, and they realized that they were not finding probable cause in their complaints. They now currently make their findings in writing. But according to this record, there's absolutely no finding of probable cause.
So the complaint was issued without any consideration of the evidence? Or just it wasn't reduced to
That
writing
is what
as
the
the rule
record
requires?
reflects and is my understanding. And again, this occurred at 4:30 at night. 2 of the other defendants that had been involved were simply released on bail. And at 4 o'clock in the afternoon, the district attorney comes forward with a motion for the juvenile to be held and asserts that it's an automatic detention. And that is an absolutely frightening concept in regards to due process and for a juvenile and his parents. With regard to...
No, it's a juvenile. Well, you may be right in this case where there has been no, I'm assuming for a moment, that an independent magistrate hasn't reviewed the evidence and determined that there's probable cause.
That's right.
But if that has occurred, and this is arson is a very serious offense, it's enumerated in the statute, and the Commonwealth demonstrates good cause for a continuance, that's what the statute says.
Well, and I think that the statute requires 2 things. One is the probable cause determination. And I think at that point, the defendant...
Probable cause to arrest.
Probable cause to arrest, that's
Which
correct.
an independent magistrate has already determined based on evidence.
Except not in this case. But
Okay, well-
hypothetically, that could occur.
Well, put it this way. Shouldn't the judge, at a minimum, and I think Ms. Montori is not arguing with that, the judge has to make some determination. I don't know what the standard of review is. That probable cause has been established in this case, correct?
Correct.
I mean, you're saying this is the wrong case because there was no probable cause, no evidence of probable cause. In fact, there's evidence of no probable cause because the particular crime was subsequently dismissed, correct, or not?
Correct.
But at minimum, at very minimum, the judge, if there's to be any kind of, quote, automatic detention, and I think Ms. Montori just said this, the judge has to determine that there's some kind of, that there's probable cause for the particular offense that would trigger the 58A detention, and that there's good cause, correct?
That is correct.
Now, I know that this is not your case, and you may just say, I'm not going to answer that, but let us assume that you had a finding of probable cause or determination by the judge that, in fact, probable cause had supported the issuance of the complaint. The judge says, well, you know, I've taken a look at the clerk's explanation, or I've taken a look at the Commonwealth's affidavit is on information and belief there's been a crime committed. Doesn't seem to me that helps very much. And then the judge determines that the Commonwealth cannot get its police officers there that day. Is it your view that, and the judge determines that that's a good faith explanation, that that's good cause to continue it, is it your view that the judge then has discretion to detain or no discretion?
And so are you saying that the judge has found good cause? Because I think that in order for the judge to find good cause, not only would a police officer need to be present, but there would need to be some offer of proof. Remember, the initial intention of the statute is to hold dangerous people. And probable cause to arrest is a very...
Why can't the prosecutor read the police report?
Well, I think, and I made this analogous to a probation revocation hearing. I'm not saying that you have to have a live police officer, but I would like some reliable hearsay. And in this case, the police report only said 2 fires were deliberately set.
Forget about this case. Let's suppose you've got a case where the police report is more detailed, 2 fires set, defendant seen pouring the gas, or juvenile seen pouring the gasoline on the first one. Why do you have to bring in a live police officer to support probable cause on that one?
Well, then I think you get into the Durling analysis and whether or not that's reliable hearsay. If you have an eyewitness who says, if my client was seen saying burn, I want to see things burn, then I think the Commonwealth needs to give an offer of proof that they're trying to get his mental health records, or they have this statement.
But this is probable cause to arrest only for purposes of getting a 3-day continuance to have a substantive hearing on all of these issues.
And I'm going to the good cause portion. Probable cause to arrest, but I think that the Commonwealth will never have their officers ready if that is good cause.
And if they comply with our rule, literally the judge could turn and rely on the complaint, which had to be based on probable cause, finding by an independent magistrate.
And say, like now, and this is where I think the Commonwealth says the judge doesn't have any discretion, and Judge Clampton appears to say she doesn't have discretion either, which is to say, you can say, right now for this 3-day continuance, I'm going to give you the 3 days continuance to put on whatever evidence you want to put on in 3 days' time, but I don't think based on this police report that I am going to detain this defendant. In other words, she's not forcing the Commonwealth to proceed with a 58A hearing, but she's saying I don't have to detain the defendant. Ms. Montori says, no. If she's letting me proceed in 3 days' time, then she must detain the defendant. And what concerns me about that, it puts the judge in the very difficult position of, in a sense, collapsing the two things, namely, what's reasonable for the Commonwealth, because there may well be a good reason to detain this person under 58A, which is a very serious statute. Commonwealth may want to put on evidence. The Commonwealth may want to put on evidence. But the judge is not satisfied based on what's presently before the judge that, she or he is inclined to detain the defendant for 3 days.
And I understand that. And that's why this is a bad case to decide it on, because when this case came in and the Commonwealth hands the motion, it looked very bad. And in the case where we have a good case, where there actually is probable cause, and we have a case where the Commonwealth is saying they have good cause, I think that that good cause determination needs to be, I don't have my officer present, but here's an offer of proof, what I'm going to prove at the hearing in relation to the statute and what I need, and that's why I need good cause. And that protects the rights of the defendant. To simply walk in and say, probable cause, very low standard, good cause, police officer not present.
But what you're saying is a very practical and realistic way to apply the statute. I guess I'm not disagreeing with you on that. But that doesn't require an evidentiary hearing, number one. In fact, the prosecutor here, I'm reading the prosecutor's statement to the court, sure is probable cause in my mind. There was an arson, an investigation. This juvenile was arrested. He admitted he entered the building through a rear door, searched the building for valuables, was with other subjects who removed items, and 2 fires were deliberately set in the structure. That's her presentation of the facts.
And the reason why it's so bad is because that was the same exact police report for the other 2, the exact same recitation.
Maybe they all
of
did.
facts.
They were all arrested together. They all admitted they did it.
But I think that my client should have a right at the probable cause hearing because the statute does say upon a showing, he gave a statement to the police. His parents were there. There was other statements made to the police. The reality of the facts was my client wasn't even in the building when the fire was set.
Oh, I see. So what you want is at the initial thing, 4 o'clock in the afternoon, they could make an offer proof, and the judge could say, okay, that looks to me like it's probable cause. But then 3 days later, you'd want them to revisit that issue with an evidentiary hearing. Is that what you're saying?
An evidentiary hearing on the 58A.
Well, and on the, not only on the dangerousness, but on the probable cause. Is that what you're saying?
Well, in this case, I should have challenged the probable cause right away. I didn't know that.
No, I'm talking about the next case.
But in the next case, I would revisit the issue of probable cause. At the time of the detention, I think the defense counsel needs to demand an immediate hearing.
Well, you did that.
And
you said, I want a hearing now. She said, I'm not going to give you a full hearing. So I'm trying to think, this may well be a case that, A, there's probable cause, and B, if that's, and the defendant gets up, makes an offer of proof and says, you know, just my client's parents were there, I heard what he or she said to the police officers, it's not at all what's in this police report. The Commonwealth doesn't have time to get the police officers in. The judge is not going to have that kind of full-blown evidentiary hearing. So the judge can either say there's no probable cause to support the complaint, and I'm trying to say no, that cannot be the inquiry at that point. But the judge doesn't have to say there is probable cause. There may be, I'm inclined to think there's probable cause, but I haven't heard all the evidence, but not sufficient for me to detain this defendant for 3 days, although I am going to permit the Commonwealth to go forward in 3 days.
I think that's why the court needs to enunciate more what Mendoza said and what is good cause. And we need to really look at this statute so it's not used improperly to hold people for what I would call improper purposes. Good cause is this defendant really a danger, or is he a 15-year-old kid that was following other kids? And that's the issue. Is he a pyromaniac?
But how is that to be resolved? That's exactly the kind of thing that you will argue at your evidentiary hearing, which will happen within 3 days.
And that is why I'm suggesting that the Commonwealth's position that unless the judge says, I determine there's no probable cause, or the judge says, no, I'm not going to give you a continuance, the judge must detain. I don't know of any other situation where that's the case. In other words, what the judge has to look, even if it's only a peekaboo look. I hear that you're going to put on a whole evidentiary hearing, Commonwealth, but I have a proffer from Ms. Montoya and I have a proffer from Ms. Kushner, and they both, I'm not asking you to call your witnesses, and I'm not going to foreclose you from having an opportunity to cross-examine the police officer or cross-examine the parents, frankly. But I've got a determination right now about 3 days of detention.
And I would state to you, if the statute says automatic detention without any, not trying to find out anything about whether the person is a danger, that you have a due process problem. An automatic detention based on a predicate offense without any individual information about, in my case, a juvenile, or in someone else's case, an adult defendant, could result in an improper detention. And I think that due process really requires that before we put someone in jail, or before we put somebody in a juvenile detention setting for 3 days, we need to really look and see why.
So in your view, you would have to have 2 evidentiary hearings under this statute.
I'm asking for a probable cause determination, and I suggested...
Are you asking for an evidentiary hearing twice under this statute?
I'm asking that the defendant be allowed to participate.
All I'm asking you is, are you asking for an evidentiary hearing before the 3-day continuance and another evidentiary hearing for the detention hearing?
I guess I am.
Evidentially?
Well, at that point, if the Commonwealth at 4:30 is trying to hold my criminal defendant and my client's parents can say that's not what was said to the police, I would want to put them on and have them tell the judge that the facts are an error in the police report.
Why can't you just make such a representation to the court?
As long as I can, then I would.
Yeah, so that you don't need an evidentiary hearing, as long as you're at least permitted to argue to the judge that there is not probable cause.
That's correct. And I guess my same principles as Durling. If I have the parents standing there and I make an offer of proof, then I think, again...
The court can decide to hear you or not. I guess my point of view is I think the statutes, it seems to me that the court could also rely on the issuance of the complaint, assuming the complaint was properly issued.
The only thing that I would state to that is that the statute says upon a showing. So it asks for a little bit more than reliance on an ex parte proceeding with a magistrate who has day-to-day...
No, that's what I'm suggesting. It's not an ex parte proceeding. That is to say, the judge has to take a look at.
That's correct.
It doesn't have to be evidentially. The judge has to take a look at. As I understand this judge's ruling, which is contained in the record, it's from the bench, she says, as I understand her ruling, if the Commonwealth requests a continuance...
Yes.
And if I'm inclined to grant the continuance, then I don't have any discretion but to detain this defendant. And she makes no reference to having even looked to see whether or not there was probable cause or there's any basis to believe that whatever...
Well, she asked for a recital of the facts, and the DA gets up and recites the confession and the whole bit. So that's not exactly the case.
And she said that's not enough. She said that's not enough because of... We had 2 other defendants in here this morning, and you weren't asking for a dangerousness hearing. Now the press is standing outside, and you come in with a motion and say they should be automatically...
Oh, well, that's different. She said that's not enough for probable cause?
She said, well, on page 8, she said, in the meantime, I have to show good cause. So you need to do a little more than that.
That's different.
If you look at page 6 of her ruling...
Page 6, she said, I'm just considering. On page 7, she says, I was waiting, and I don't understand the sentence, I was waiting only on probable cause to have been arrested is what this showing is for that, and I'm showing good cause for it, and I don't understand what that sentence means. But then after that, she specifically says, in the meantime, I have to show good cause, so you need to do a little more than that. And she rereads the police report, the DA, and she says, as I mentioned before, and then the judge says, no, that's not enough. I again would raise my issues of the procedural issues, and I would rest on my brief.
Thank you, Ms. Fletcher.
I don't see that.
We have one more case.
Was that been argued?
I'm off of this one.